Dominica is currently constructing its first international airport, a $370 million project designed to expand the island's global connectivity and economic reach. Building a 3,000-meter runway across a rugged, mountainous island requires millions of tons of heavy stone. Sourcing this material locally is a logistical requirement to manage construction costs and keep the project on schedule. To supply that stone, the government selected the Dew Branches Quarry. It sits close to the construction site in Wesley, but it also borders the watersheds of the Northern Forest Reserve. Operations at Dew Branches triggered immediate opposition. Local residents, environmental activists, and Indigenous leaders organized protests, citing heavy sedimentation in local rivers and violations of the island's statutory environmental codes. Sourcing aggregate for a runway has become a specific test of the island's legal framework. The daily operations at the quarry are challenging the application of environmental laws and the land rights of the Indigenous Kalinago people. The rules for extracting local earth are clearly defined. Under Dominica's Physical Planning Act, any major quarrying operation requires a thorough environmental and social impact assessment, a public study mapping out ecological risks and mitigation strategies. Activists discovered that the initial assessment submitted for Dew Branches contained pages copied from two unrelated projects. Furthermore, the mandatory consultations with the neighboring Kalinago territory never took place. When regulatory compliance fails, the state can issue a stop order. This administrative action forces developers to halt all site operations until the underlying breach of the Planning Act is resolved. This diagram illustrates a tactic called bifurcation. Instead of resolving extraction issues, the applications were split to permit separate rock crushing equipment installation. Once approved, activists reported that active earth-moving resumed. This limited permit bypassed the original stop order, allowing extraction to continue. Splitting permits to bypass regulatory halts creates a breakdown in oversight, allowing work to proceed without the environmental safeguards required by law. The government's technical defense is that the Dew Branches site is strictly a quarry, extracting high-density basalt for the airport's runway foundation. However, an independent geological study, led by Professor Simon Mitchell of the University of the West Indies, presents a different assessment of the site's geology. This cross-section demonstrates Mitchell's finding: hydrothermal alteration. Superheated fluids weakened the rock at Dew Branches, leaving it structurally unfit for an international runway's immense weight. The study also confirmed copper deposits throughout the site, aligning with a historical mining operation halted by national protests. The law distinguishes between construction aggregate and metallic minerals. Digging up basalt for construction is quarrying, but intentionally extracting metallic minerals is legally classified as mining. If the operation is extracting copper, it is governed by the Mines and Minerals Act. Operating a mineral mine under a standard quarrying permit would be an ultra-virus act, meaning the government has exceeded its legal authority, potentially making the current permits void. Finding copper at the site changes the technical debate. If the site is actually a mine, the government's current legal defense for the quarry changes, providing a basis for demands to halt operations. The Kalinago territory and environmental groups have several judicial options to enforce government compliance and transparency. One option is filing for judicial review. By demonstrating procedural impropriety or potential for irreparable harm, citizens can seek an interim injunction, a court order that freezes all heavy machinery on site until the legality of the permits is determined. Because the Pagua River flows from the quarry into the Kalinago territory, Indigenous leaders can file a constitutional motion. They can argue that river pollution deprives their community of fundamental rights regarding property and a fair hearing. If domestic courts do not resolve the matter, the case can be brought to the Caribbean Court of Justice. The CCJ has established precedents requiring states to protect Indigenous land and water rights from environmental degradation. This breakdown of the Escazú Agreement highlights specific rights guaranteed by international law. Dominica ratified this treaty in 2024, binding the state to provide citizens with access to environmental data and a role in decision-making. Constructing an international airport does not require bypassing the laws that protect the island. By pursuing these specific legal actions, citizens ensure that infrastructure growth remains accountable to the rule of law.